Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.
People v. Roderick Collier, decided January 8, 2026. Garcia, J. Defendant pled guilty to one count of sexual misconduct, a sex offense requiring registration under the Sex Offender Registration Act, SORA. Nevertheless, defendant was not notified of his SORA registration requirements, and approximately 6 years passed from the time of his plea before this mistake was brought to the attention of the Board of Examiners of Sex Offenders. After a full, albeit delayed, SORA proceeding, defendant was designated a Level 1 sex offender, the least restrictive designation available, with the required 20-year registration period ordered nunc-pro-tunc from the date of his release. Defendant claims that the delay between his plea and his SORA hearing violated his substantive due process rights. We disagree and hold that defendant failed to make the required showing that the delay prejudiced his ability to present his case to the SORA court, and for that reason, we affirm. SORA was designed to protect the public from the danger of sexual recidivism posed by individuals who commit certain sex offenses, People v. Weber, by requiring them to register with law enforcement officials and authorizing the dissemination of certain information about those individuals to vulnerable populations and the public, People v. Migmo. A defendant's registration and notification obligations correspond to a designated risk level within a 3-tiered classification scheme, levels 1, 2, and 3 in ascending order of risk, that seeks to capture the offender's risk of reoffending, People v. Francis. To determine an offender's risk level, the board completes a case summary and risk assessment instrument, RAI, that assigns points based on various risk factors, including the offender's criminal history, the age of the victim, and whether the crime involved violence, Francis. The assessment of points under each risk factor results in an aggregate score that presumptively places an offender in a particular risk level, Weber. Based on its points assessment, the board makes a recommendation to the SORA court regarding the offender's risk level, and the court, which has the ultimate responsibility of designating the offender's risk level, must conduct an independent review of the evidence and may either accept the board's recommendation or depart from it and assign a different risk level classification. Francis, see People v. Galoti. The statute mandates that the board make its recommendation within 60 calendar days prior to the sex offender's discharge or release, Correction Law 168 L6, and the SORA court must hold its hearing to determine the sex offender's level of notification no later than 30 calendar days prior to the sex offender's discharge, Correction Law 168 L2. Additionally, the original sentencing court must certify that the person is a sex offender and advise the sex offender of his or her duty to register, Correction Law 168 D1A. Nevertheless, a failure by the board to act or by a court to render a determination within the time period, Correction Law 168 L8, or a court's failure to include the certification in the order of commitment or the judgment of conviction, Correction Law 168 D1A, shall not affect the obligation of the sex offender to register under SORA, or prevent a court from making a determination regarding the sex offender's level of notification and registration period, Correction Law 168 L8, 168 D1A. Nor does a court's failure to advise a defendant that he or she would be required to register as a sex offender undermine the voluntariness of a guilty plea. See People v. Gravino, People v. Cadu, holding that the failure of a court to advise the defendant that his sentence included a mandatory period of post-release supervision required vacatur of his plea. Those convicted of a qualifying sex offense must be registered at one of the 3 available risk levels. In other words, the minimum available designation is Level 1, and the minimum term for registration is 20 years. In April 2009, defendant, then 22 years old, physically assaulted and raped a 16-year-old female acquaintance after she turned down his sexual advances. He was charged with various offenses, including first-degree rape, Penal Law 130.351, but eventually pled to one count of sexual misconduct, Penal Law 130.201, a misdemeanor offense. At the time of his plea, the court informed defendant that he would be required to pay a $1,000 sex offender fee, but did not certify defendant as a sex offender or inform him of his obligation to register under SORA, Correction Law 168 D1A, 168F. Defendant was given a 1-year prison term and was released without supervision in December 2009 after serving approximately 8 months of his sentence. Although defendant's sexual misconduct convictions subjected him to the registration and classification requirements of SORA, see Correction Law 168A-2A, the board did not make a recommendation regarding defendant's risk level prior to his release, and no SORA hearing was held at that time. Accordingly, no judicial determination was made as to defendant's risk level, and defendant remained unregistered for nearly 5 years. While unregistered, defendant was hired by a social services agency as a youth specialist/cook at a non-secure placement program for children between the ages of 12 and 16 who had been remanded there by family court. Other than a traffic infraction for unlicensed driving in 2013, defendant had no contact with the criminal justice system. In November 2014, the New York State Sex Offender Registry brought defendant's conviction to the board's attention, and the board prepared a case summary and RAI recommending that defendant be classified as a Level 2, moderate risk, sex offender. The RAI assessed 15 points under Factor 1 for inflicting physical injury upon the victim, 25 points under Factor 2 for having sexual intercourse with the victim, 20 points under Factor 5 due to the victim's age, 5 points under Factor 9 for defendant's prior criminal history, and 15 points under Factor 14 for being released without supervision, for a total of 80 points. The board did not recommend a departure from defendant's presumptive Level 2 risk classification. Defendant moved to dismiss the SORA proceedings, arguing that the delay between his guilty plea and the SORA hearing violated his state and federal due process rights, and that, as a result, the court was precluded from assigning him any risk level. Alternatively, defendant asked that he be registered as an unclassified offender, eliminating the community notification part of his sex offender registration. The court rejected these arguments, noting that doing so would take out the underlying rationale of the SORA Act itself, and denied the motion to dismiss the proceedings. However, the court granted defendant's request not to assess the 15 points under Risk Factor 14 relating to release without supervision, reducing the total to 65 points, which brought defendant's designation down to a Level 1. The court also agreed to enter the order nunc pro tunc from the date of defendant's release from custody, and as a result, the 20-year registration period required for a Level 1 offender runs from defendant's December 2009 release date, rather than his initial date of registration in March 2015, Correction Law 168H1. The Appellate Division affirmed, while noting that the correction law is flexible and requires a sex offender to register regardless of any failure by the state to act, the court nevertheless concluded that an offender's due process rights are violated when a delay is so outrageously arbitrary as to constitute gross abuse of governmental authority, quoting People v. Myers. To determine whether a delay is outrageously arbitrary, the court adopted a modified version of the speedy trial test laid out in People v. Taranovich, weighing the length of the delay, the reason for the delay, whether the defendant was on notice of the SORA registration requirement, and whether the defendant was prejudiced by the delay. In weighing the factors, the court noted that the absence of prejudice is most critical in view of the facts of this particular case, quoting Taranovich, and concluded that defendant had in fact materially benefited from the delay because his conduct during that time led the SORA court to reject the assessment of 15 points, thereby reducing his risk level from Level 2 to Level 1. Therefore, the court held defendant's due process rights were not violated. The substantive due process violation claimed here, the delay in commencing SORA proceedings, is an executive act, and we must therefore determine whether such conduct shocks the conscience. County of Sacramento v. Lewis, Gonzalez Fuentes v. Molina. See also People v. Lingle. To do so, defendant proposes that this court adopt, as did the appellate division below, an approach based on Taranovich that balances certain factors in determining whether a due process violation occurred, but instead strike the balance in his favor. We disagree that such a test is suitable here. Taranovich is grounded in the Sixth Amendment right to a speedy trial, which has no application beyond the confines of a formal criminal prosecution, Doggett v. United States. As we have reiterated on numerous occasions, SORA is not a penal statute, and the registration requirement is not a criminal sentence. Rather than imposing punishment for a past crime, SORA is a remedial statute intended to prevent future crime, People v. Perez. Because SORA proceedings are civil, not criminal, speedy trial concerns are not implicated. See generally People v. Watts. Similarly distinguishable are sentencing delay considerations, where the focus of the court's inquiry is on the defendant's right to appeal, his eligibility for pardon and commutation of sentence, and, if a retrial becomes necessary, the danger that witnesses may be unavailable. People v. Drake. Given these concerns, we assume that a criminal defendant has been prejudiced by a sentencing delay, and whether dismissal is warranted depends upon the length of the delay and the reasons for it. A sex offender's liberty interest, on the other hand, differs from the fundamental rights at issue in the context of criminal prosecution and sentencing. SORA risk level classification implicates a private liberty interest and triggers due process safeguards. Nonetheless, this liberty interest does not rise to the level of a fundamental right or trigger a requirement that the state shield a sex offender from the social stigma flowing from their criminal conviction or an accurate assessment of their risk to the community. For that reason, although the liberty interest at stake here is not to be discounted, it is more limited than the interest threatened by a criminal proceeding, where an innocent person may be inaccurately branded a criminal and subjected not only to unjust stigma, but the complete curtailment of liberty through a prison sentence. Watts. With respect to procedural due process, we have held that while sex offenders are entitled to certain due process protections at their risk level classification proceedings, those protections, quote, are not as extensive as those required in a plenary criminal or civil trial, end quote. People v. Baxon, quoting Doe v. Pataki. Nevertheless, the consequences of registration and notification under the Act are sufficiently serious to warrant more than mere summary process. Baxon, and this state accordingly provides significant protections, including notice that a risk level determination will be made, broad pre-hearing discovery, an independent review of the evidence by the SORA court, and an opportunity for the defendant at the SORA hearing to present evidence, call witnesses, and challenge the board's point assessment and risk level determination. Correction Law 168N2. Francis. See also People v. David W., holding that the procedures employed for defendant who was serving a sentence of probation when SORA took effect did not provide adequate notice or opportunity to contest his risk level assignment, and were therefore inadequate to mitigate the risk of an erroneous determination that a sex offender on probation is a sexually violent predator. Defendant was afforded these procedural safeguards at his SORA hearing. Applying these general principles to the substantive due process claim here, based on the delay in initiating SORA proceedings, we hold that to establish a violation, a defendant must make a showing that the delay prejudiced his ability to present his or her case to the SORA court. Furthermore, in the context of a delayed SORA proceeding, the remedy for prejudice to that interest must be applied within the SORA framework. Defendant does not contend that the delay caused any specific risk assessment factor to be scored against him, or that he otherwise suffered prejudice at the hearing. Nor could he, considering that, as the Appellate Division correctly noted, he materially benefited from the delay. The SORA court, taking into account defendant's nearly 5 years of unsupervised release with only a minor traffic violation, declined to assess 15 points under Factor 14, release without supervision, reducing his classification from a presumptive Level 2 offender to Level 1. Instead of a lifetime registration requirement under Level 2, defendant is required to register for 20 years, and because of the Noc Pro Tunc order, his registration period will in effect be 14 years, with more limited public dissemination of his information. Defendant, in large part as a result of the delay, is now subject to the least onerous and intrusive conditions a court may impose on a sex offender required to register under SORA. Accordingly, the delay here does not shock the conscience. Even assuming that defendant's substantive due process claim can somehow be taken as a challenge to a legislative enactment based on the mandatory application of the SORA statute despite the delay, see Correction Law 168L8, failure by the court to act does not relieve a sex offender of obligation to register, the claim must be rejected. For that analysis, we must consider whether the claimed violation was to one of those fundamental rights and liberties which are objectively deeply rooted in this nation's history and tradition. Hawkins v. Freeman, quoting Washington v. Glucksberg. We have assumed that defendants have a constitutionally protected liberty interest, applicable in a substantive due process context, in not being required to register under an incorrect label, People v. Knox, concluding that the interest defendants assert in not having their admittedly serious crimes mischaracterized in a way that is arguably even more stigmatizing or more frightening to the community than a correct designation would be, is not constitutionally significant. while Knox involved defendants claiming they were mislabeled as sex offenders based on their convictions for crimes that did not involve any sexual act or sexual motive. Similar concerns apply where a SORA proceeding is delayed, and a defendant's ability to present arguments or proof may be affected. The same analysis above concerning prejudice applies to the risk of mislabeling. Defendant must show he was prejudiced by the delay in presenting his case to the SORA court, which he has not done here.
Lastly, we reject the idea that defendant's expectation that he would not be required to register as a sex offender had somehow crystallized to the point of becoming a protected liberty interest. See Hawkins. See also People v. Lingle. The amorphous, heavily subjective nature of such an asserted right, based as it is on notions of sufficient temporal duration, sufficiently good behavior, and crystallized expectations, is not the traditional stuff of substantive due process rights. Hawkins. Given the lack of any fundamental right to this expectation by a sex offender whose SORA proceeding has been delayed, the test becomes whether the statute is rationally related to legitimate government interests. Glucksberg. We have no difficulty in concluding that, given the state's public safety interest in ensuring sex offender registration and community notification, see Weber, the legislation requiring such registration, even if delayed, passes that test.
There is no occasion here to consider whether any such circumstances might, in an appropriate case, support an application for a downward departure. See People v. Gonzalez. In a case involving multi-year delay in holding a SORA hearing, the court held that although defendant demonstrated by a preponderance of the evidence that he had not been convicted of any sex offenses in the approximately 14 years following his release to probation, which is a mitigating factor not adequately taken into account by the SORA guidelines, the SORA court providently exercised its discretion in denying a downward departure given the grievous nature of the defendant's offense and the danger he poses to society should he reoffend. People v. Welles, finding no due process violation where, despite an 18-year delay between the defendant's sentencing and his SORA hearing, the defendant was able to establish at the SORA hearing that a downward departure from risk level 2 to level 1 was warranted, due to the time the defendant spent on supervised release for a sex offense he was convicted of in another state during the period of delay. A downward departure analysis in these circumstances fits within the SORA framework, and as with an adjustment of points made to remedy potential prejudice resulting from the delay in the proceedings, provides an avenue for relief while adhering to the public safety goals of SORA. Accordingly, the order of the appellate division should be affirmed, without costs. Order affirmed, without costs. Opinion by Judge Garcia. Judges Rivera, Singas, Canataro, and Troutman concur. Chief Judge Wilson concurs in result in an opinion, in which Judge Halligan concurs. Decided January 8, 2026.
Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.